All right, a very warm welcome to our seminar this evening on modern slavery. So before we start and before I properly welcome you, I'd just like to acknowledge that I'm hosting this webinar from the lands of the Camaragal people. And I also acknowledge the traditional custodians of the various lands where you are all on today, and the Aboriginal and Torres Strait Islander people participating in this seminar. So thank you so much for joining our discussion this evening on modern slavery. And I'm absolutely delighted to have the Shadow Attorney General with us this evening, Mark Dreyfus, QC. He's a Melbourne barrister and was appointed Queen's Counsel in 1999. So in 2007, Mark was elected to the House of Representatives as the member for Isaacs. In 2010, he was appointed Cabinet Secretary and Parliamentary Secretary for Climate Change and Energy Efficiency. In 2013, he was appointed Attorney General and Minister for Emergency Management. Mark is a passionate defender of the rule of law, freedom of the press, and the need for a powerful and independent National Anti-Corruption Commission. And he's got a particular commitment to creating a sustainable economy, an environment for future generations, and a long-standing advocate for our First Nations peoples. We're also lucky to have Dr. Dominic Ma with us this evening. Dr. Ma is Deputy Director of the John Curtin Research Centre and the Centre's inaugural Chief Economist. Dr. Ma's been a visiting fellow at ANU's National Universities, the Australian National Universities College of Asia and the Pacific, and he was Executive Director of the Australasia Strategy Group. His PhD in economics is from ANU. And we also have me. I am the Labor candidate for the seat of North Sydney. I'm a professor in the School of Law at Western Sydney University, and I'm a lawyer, and my PhD is from the University of Sydney. So just about this panel, what you've come along for this evening. We want to speak briefly, each of us, about what modern slavery is, and I'm going to talk about that, about Australia's efforts to address the problem of modern slavery and recent legislation we've enacted to that end, and the Shadow Attorney General is going to discuss that. And then Dominic is going to take us through perceptions of weaknesses in the current regime and anything that might be done to address those weaknesses. So we want to keep our formal comments relatively short so that there's time for discussion and questions from the audience at the end. But before we get into it, I thought I might just mention the reason why we chose this particular subject to talk about this evening. There's so many things that we could be talking about. There's so many problems, awful things happening all over the world. And I think a lot of us have a sense of powerlessness right now. We know that there's been allegations of war crimes being committed in the Ukraine, for example, and there's calls all over the world for tribunals and courts to hear those claims and try the perpetrators. But we know that there's very little chance of the people who are responsible for those atrocities being brought before international courts anytime soon at all. So there's a sense of helplessness that we have. But the problem of modern slavery is something that we can address, and Australia has made a valiant attempt to address it. And it's rather a creative way that we've tried to do that, bringing business along with us, asking them to address their supply chain issues and relying on consumers to have eyes wide open about incidents of human slavery that they might be witnessing around them. So this particular topic, it's a sign of hope, I suppose, at a time when we might be feeling quite bleak about the power of us as countries to do things about atrocities that are happening far away from us. So first of all, I'm going to start by asking the question of, well, what is slavery? itself. And it's not actually such an easy matter to define what slavery is. There's a generally accepted legal definition in the League of Nations Slavery Convention back in 1926. And that hinges what slavery is on the conditions of ownership. So if you're a human being that's owned by someone, then slavery is taking place. On this definition, slavery has existed for thousands of years. Owning people is something that's happened in ancient times and in modern times in different societies across the world. What we most commonly think of was the imperial form of slavery, where the colonial powers, Britain, France, Belgium, Brazil, transported people from their homes, mainly in Africa, and sold them to landowners and people mainly in the Americas. And their slaves endured lives of misery, privation, and dislocation. They could be resold, traded, separated from their children. Every aspect of their lives was controlled and directed towards the exploitation of their labor. And slavery was supported by judicial arrangements that made the ownership of persons legal and state sanctioned. So this form of slavery was officially abolished in May 1888, when Brazil finally declared the end to slavery. And 40 years after this, we had what was the world's first international human rights treaty, and it was aimed at preventing slavery from taking place ever again anywhere in the world. Since then, slavery's been identified as one of the few jus cogens norms of international law. That means one of the laws that can never, ever be broken. There's no excuse for breaking it. There are no circumstances in which a country can ever say slavery was justifiable. It's a fundamental value that must be upheld, no exceptions. So it's in the same league as torture in that regard and genocide. It's prohibited in a lot of international instruments, in the International Covenant on Civil and Political Rights, the Rome Statute of the International Criminal Court. Australia's a party to both of those international treaties. And slavery is prohibited in all of the major regional international human rights covenants. So the European Covenant, the Americas, ASEAN's covenant prohibits slavery as well, and that of Africa. So that's classical slavery, but what's modern slavery? The key point with modern slavery is that the understanding of slavery has been expanded beyond a focus on ownership to include things like forced labor and servitude, debt bondage, and trafficking. So forced labor is where your work or service is exacted under the menace of a penalty. So it's not voluntary. And debt bondage is when the debtor pledges their personal services as security for a debt. Trafficking is recruiting or transferring people through force or fraud or deception with the aim of exploiting their labor. And child labor is all of that bundled up in relation to children, but it also includes the use of children in armed conflict. So we've got a set of international guidelines that help us identify what slavery is and when it's occurring, the Bellagio-Harvard guidelines on the legal parameters of slavery. And unlike classical slavery, they emphasize control over a person that doesn't necessarily mean ownership. They recognize that you can control people in different ways and exploit their labor through controlling them, usually involving deception or coercion, threats. People are treated as a commodity, they're not free to leave, and they're subjected to slavery in those circumstances. So in Australia and in much of the world, doing that is illegal. The problem we have is in recognizing when it's occurring. In some circumstances, control of someone might be physical. But physical constraints won't always be necessary to maintaining effective control over someone. You can withhold their identity documents, restrict their free movement, or you could force them to adopt a new identity, a new religion, or a marriage. So that's the big difference. Ancient slavery was legal ownership. Modern slavery is practical ownership through control. And why it is a jus cogens norm, what slavery does, why it's absolutely prohibited and is regarded as one of the worst violations of international law, is that it dehumanizes a person. It deprives them of their fundamental liberty so that they can be used for profit. And finally, just a word about what makes people vulnerable to slavery. So there's a lot of research being done on this. And what we know is that environmental disasters or displacement, health crises, migration through hunger, malfunctioning justice systems, and discrimination are all things that increase the vulnerability to modern slavery. It's related to the absence of protection for rights. But conflict particularly destabilizes entire populations and destroys people's safety nets, removing the protections of the rule of law. We saw this clearly in World War II, when hundreds of thousands of Eastern European women were transported into slavery in Germany, and in our own region in the Second World War, from Korea into Japan. But just 6 years ago, we saw ISIL and Boko Haram engaged in the sexual enslavement of women and girls through trafficking. And right now, in Myanmar and in Afghanistan, women are vulnerable to trafficking again. So what about slavery in Australia? It's less prevalent than in other countries, but we do have forced labour, sexual exploitation, and forced marriage. In 2019, we had our first conviction under forced labour laws. That involved a Brisbane couple who were sentenced to 5 and 6 years jail for forcing a Fijian woman to work as their domestic servant for 8 years with very little pay. We know that sexual exploitation represents about 30% of slavery cases. But the most prevalent form of modern slavery in Australia is forced marriage, being tricked, forced, or coerced into a marriage without your full consent. Globally, however, the most common form of slavery is forced labour. An estimated 25 million people are forced to work through the use of the threat of violence or physical, emotional, or financial restraints. And this kind of slavery is what we're going to talk about this evening. It thrives in the regulatory gaps of global supply chains. They're common in textile making, fishing, manufacturing, extractive industries, mining, brick making, agriculture. And over the past 20 years, there's been a global effort to address this form of slavery and an increasing move to make corporations responsible for looking at slavery in their global supply chains. So in 2015, the UK adopted the Modern Slavery Act, and it focuses on the prevention and prosecution of modern slavery. Australia took longer than the US and the UK to move towards framing egregious labour exploitation in terms of modern slavery and to develop a legislative response. But in February 2017, a parliamentary inquiry was announced into whether Australia should have a UK-style Modern Slavery Act, and if so, in what form? And finally, on 1 January 2019, the Modern Slavery Act commenced. And to take us through that act and what it means for Australian companies, we have the Shadow Attorney General, Mark Dreyfus. Over to you, Mark.
Thanks very much, Catherine. And I'm coming to you from the lands of the Wurundjeri people of the Kulin Nation in Melbourne. And I pay my respects to their elders past and present. And as you've heard from the Leader of the Opposition, recommit Labor in government to a referendum on the voice, to implementing the Uluru Statement from the heart, which is one of the many good reasons to be electing a Labor government. And I'm looking forward to Catherine joining me as a member of the Federal Parliamentary Labor Party. It will be good to have, as part of the Federal Parliamentary Labor Party, someone with acknowledged expertise in human rights. Acknowledged expertise in human rights is something that has been sorely lacking in this current government, who had to be dragged, I've got to say, kicking and screaming to the Modern Slavery Act that came into force on the 1st of January 2019. And it's got a pretty sorry history in Australia. It should have happened a lot earlier than it did. As Catherine's noted, the then Attorney General George Brandis in February 17 asked the Joint Standing Committee on Foreign Affairs, Defence and Trade to inquire into and report on establishing a Modern Slavery Act in Australia, and that is already 2 years after the British had legislated on this subject. We had the somewhat strange experience of the Independent Anti-Slavery Commissioner from the United Kingdom come to visit us in Australia in 2017. I had the honour and pleasure of meeting him and hearing about his activities, and we could not get the Turnbull government, or for that matter the Morrison government since, to accept that the model that has already long now been established in the United Kingdom of having an independent anti-slavery commissioner was the way to go. We were agitating already in 2017 and called for a Modern Slavery Act. This was before the Joint Standing Committee reported, but I and my then colleague as the Shadow Minister for Justice, Claire O'Neill, called very, very loudly for a Modern Slavery Act. And it's something that we continue to call for. Eventually, a modern slavery bill arrived following the committee report. It arrived in the House of Representatives in June 2018. It was introduced into the Senate in September 2018, and some of the amendments that we put forward were successful, but regrettably, other amendments that we moved, including much tougher penalties for non-compliance and establishing an independent anti-slavery commissioner, were not successful, and they remain really outstanding requirements, we would say. What the Act does, and it has this in common with like modern slavery legislation in other parts of the world, is to establish a modern slavery reporting requirement. It's a requirement that applies to large businesses and other entities in the Australian market, and they are large. It's companies with annual consolidated revenue of at least 100 million Australian dollars. And what it does is it helps the Australian business community to identify and address modern slavery risks, to maintain responsible and transparent supply chains. It's a requirement for entities that are bound by this reporting requirement, which includes the Commonwealth Government, to prepare an annual modern slavery statement. That statement for each of the large companies that are bound by this has to set out what actions the company has taken to assess and address modern slavery risks in their global operations and supply chains. And those statements are in turn published through an online central register. So I think it's fair to say we've made a start in Australia on this, but there's a lot more that we could do. Labor is fully behind these efforts. We called for it to happen we said that it was necessary for there to be an independent anti-slavery commissioner. And as all of you on this call can imagine, what an independent anti-slavery commissioner does, as always with independent agencies, is to publicise these issues. It's to call on corporations that are not meeting the expectations that Australians would have of all large companies operating in Australia, and take a role that's not perhaps available to a federal government minister. And we've seen very much the very productive role that's been played by that independent anti-slavery commissioner in the United Kingdom. So it's a disappointment. It's a continuing disappointment to me that 4 years on from the legislation passing through the Parliament, the government's done nothing further at all, really. They've done nothing further to pursue the idea that we put forward then of having an independent anti-slavery commissioner like the British. They've done nothing further to review the need for stronger penalties. And there's a couple of other things that I should mention that are now outstanding that I hope an incoming Labor government, if we are successful at the election, which we are on the point of having announced, there's things that an incoming Labor government will do. We will conduct a comprehensive review of our own, that is the government's procurement procedures and supply chains, and disclose this publicly as part of the modern slavery report that the Commonwealth is bound to give. The modern slavery reports that the government has thus far made under the existing legislation are a bit perfunctory, and so the role that could have been played by the Commonwealth, which is to provide a blueprint for all companies in Australia, big companies, and for state and territory governments to also review their supply chains and ensure that they are not importing goods made from forced labour, including in places like Xinjiang province. That hasn't happened. We think that the government should ratify the International Labour Organisation's 2014 Forced Labour Protocol. If Australia wants to speak with global credibility on ending forced labour, it should be joining the 45 other countries, which include our friends and allies, the United Kingdom, New Zealand, Canada, France, Germany, large developed countries like our own that have already ratified that protocol, and they already fully abide by the ILO's Forced Labour Convention. And it's a really important step. You'd have to say, sound a bit facetious here, that this Liberal government's 9-year relationship with the International Labour Organisation, let's say it's been strained. So things that the International Labour Organisation want to do, this Liberal government hasn't wanted to participate in. But lest anyone think this is some wild idea, the International Labour Organisation Forced Labour Protocol was referred to the Joint Standing Committee on Treaties of the Australian Parliament. It reported in March of this year with this key recommendation. I'll just read it out. The committee supports the proposed International Labour Organisation Protocol of 2014 to the Forced Labour Convention 1930 and recommends binding treaty action be taken. So we've got the Joint Standing Committee on Treaties ready-made, saying to the incoming government, which I sincerely hope is going to be a Labor government, do something about the ILO's Forced Labour Protocol. That's probably enough for me. I'm really happy to answer questions about this. It remains outstanding business for the Australian Labor Party. I'll finish with this. I'll just read out the paragraph in the platform. This is our platform adopted in what I sincerely hope is the only ever digital national conference that we will ever have. We thought it might be workable because the Democratic Party in the United States had a digital conference, and we had one too in April last year. It was pretty difficult, but we did arrive at a revised form of our national platform. This is what it says on this subject. Over 40 million people worldwide are trapped in some form of modern slavery, many of whom are victims of exploitation in global supply chains. Australia has an important role to play in abolishing modern slavery. Modern slavery is a hidden problem that will not be discovered without meaningful attempts to expose it. Labor will ensure that Commonwealth criminal laws adequately capture and prohibit forced labour. This includes forced labour in shipping, fishing, clothing, food production, domestic work, and other high-risk sectors. Labor will enforce supply chain reporting requirements, including mandatory reporting requirements and penalties for non-compliance. And the last sentence reads, Labor will also establish an independent anti-slavery commissioner to lead our efforts to abolish modern slavery in Australia and abroad. So that's a little potted version of where we've got to in Australia so far, where we need to get to, and I'm happy to answer questions. And I'd thank Catherine very much for putting this on. You're on mute.
Of course I am. Thank you very much, Mark. Dom, we'll hand it over to you now.
Thanks very much. I think I'm not on mute. So, and thanks very much, Mark and Catherine, for your words so far. I'm speaking to everyone from the land of the Gadigal people of the Eora Nation. I live in Redfern, and there's a long tradition of Indigenous people in Redfern that is very proud. The reason I'm involved here is because I convene a network called the Human Rights and Democracy Network, and I've been doing some work promoting some of this legislation through, or helping some of this legislation through Senate committees, or working with some of our senators in Labor on this and other sort of related work, acts, the Magnitsky Acts. I did a fair bit with Kimberly Kitching on, and we've essentially created a network of human rights activists and organisations that are, some are Labor aligned, some are not, but our goal is to help them engage with the parliamentary process, because getting this act through Parliament, it's been mentioned, I think, how long and difficult a process that was. Many people put in many hours over many years to get done. And often what happens is the people who are most passionate about it have limited access to parliamentary representation, limited resources, and can be easily shut out. So part of what we try to do is open those doors and make those connections. In terms of, I think we've already had a very excellent overview of what the issues around modern slavery are and where Australia has got to. There's at least two, maybe now three areas that I want to talk about, types of modern slavery that apply to Australia. One is temporary immigration. This is one of the areas that probably most directly applies to Australia. The second is international supply chains. And this is one where we have responsibility to act, but it's mostly external action. And the third one is the situation in Ukraine. Catherine mentioned how much war is a confounding factor and dislocation of people. And we've already heard recently about the number of people, people smugglers and sex traffickers, greeting Ukrainian refugees in Poland and other places, and tricking them and deceiving them into what we can only guess at. And I think this is going to be an area that an incoming government will need to collaborate with European colleagues, especially Poland, probably Germany and others. I think that's going to need to be on our radar. I don't think it's been part of any discussions until now, because obviously it's unfolding right now. I won't say any more about that because the other issues are more focused on Australia. Temporary immigration to Australia is one of the areas that is a significant problem for us. this is a situation where a lot of people with very insecure working rights, insecure living conditions in Australia, are easily exploitable. And I think Christina Keneally and other people in Labor have been writing about this over the last year or two quite a bit. It's an area where a lot more can be done in Australia, I think. And it overlaps with some of the other social issues that we face here around, possibly around slow wages growth and employment issues. When you have this sort of very large, potentially large pool of uncertain or undocumented or easily exploitable migrant workers, that's a condition for a lot of problems to come up. And that's one area where the legislation on this hasn't been sufficiently enforced, we think. The other major one is international supply chains. And I think this is really where the Act itself tries to focus. The legislation seems to be significantly focused on international supply chains, getting companies to report on their risks of exposure to forced labor in their supply chains, what they're doing about it, and how they're trying to fix it. The reporting, the compliance has been very poor in general. There's a range. Some companies have done complied very well. Woolworths has been seen as one of the better companies in terms of their compliance. There's a large range, and it goes to very poor compliance. Most companies are not really taking this very seriously, and the reason seems to be, Mark mentioned quite a few times, that there's no independent commissioner pushing everyone to do this. The enforcement is not there. The penalties are not there. Companies are not being listed as uncompliant, and there's no penalties if you are uncompliant. So yes, the Act finally exists. The powers are finally there. We need to make things that are illegal, actually enforced. Right now happens to be, I think this is a coincidence, a very good time to be discussing this, because the 3-year review of the legislation was announced last week on Thursday. So there's a parliamentary review process beginning immediately, and that will be a 1-year review on how the Act has been operating and any changes that have to occur or should be occurred. Members of the public can make submissions through the parliamentary process, and that will be over the next over the next 2 or 3 months. There should be submissions open. Unfortunately, that's the campaign period, so it's going to be very distracted. But that will be the period where we can potentially raise these issues in a formal way. There's another part of the enforcement of this that I want to raise that hasn't been mentioned. Part of the National Plan to Combat Modern Slavery includes research on the topic as one of the major deliveries. The funding for research on modern slavery in Australia under this plan is $4.5 million over 5 years. It is less than $1 million a year for research on modern slavery. You can basically run maybe one center of 2 or 3 academics, maybe, with that kind of money. This is not a priority for this government, and I think it should be. I'm going to come down to one of the pieces of legislation that is being put forward is Rex Patrick's private senator's bill on the customs amendment. This has been very focused on, from his perspective, forced labor of Uyghurs in Xinjiang. Forced labor, of course, is not just a China issue. Much of the issues in South Asia, in the Pacific, in all around the world, essentially. But a lot of the political debate here has been focused on Xinjiang. That's fine. It's a big issue for the Uyghurs, definitely. The amendment to the customs bill that Senator Rex Patrick has put forward has a few limitations. I think Labor have identified several of those in terms of having an open referral mechanism. Often the people that know what's going on are in the community or are human rights organizations or are victims. There's no clear process for people to just take it to the government and initiate an investigation. And that's the same in the Magnitsky Act. There's a little bit of a closed door process here. It's unclear in customs enforcement, how much investigative power agencies have, such as Border Force. What are the appeal mechanisms? What are the transparency and accountability mechanisms? Transparency and accountability, of course, are phrases that this government doesn't really love. And you can see that in the way they're implementing or not rushing to implement the Modern Slavery Act as well. There's a number of other issues that could be enforced better, but I think I'll leave it there and let people move on to questions, because if you're at all like me, it's Mark Dreyfus and Catherine Renfro that you're really here to see. So I think I'll put a bookmark in it there, and I'm very glad to see how much Labor is doing on this front. Hopefully the outcome of the election will give you the power to make it happen.
Thank you so much, Dom. Excellent. So when I first started studying at university and was interested in human rights, it was the case that there were very few jobs that you can get if you wanted to be a human rights lawyer. Like, that didn't really make sense as a career path. But the development of the space of business and human rights and evaluation of supply chains for slavery and evidence of trafficking, that is a field just ripe for people who have human rights expertise and knowledge of business and corporations. So I think it's for depressing reasons, it's a heartening time to be a young law student who's interested in human rights, because there is a need for people who have human rights expertise to do the work that businesses now have to do when they're making declarations about whether there is evidence of slavery and forced labor in their supply chains. They actually don't know how to do it, and they need people who do understand human rights to guide them through that process. I think it's inevitable that the $100 million standard for corporations will be reduced eventually, so that more and more companies will have to declare whether or not their supply chains are free of slavery. So it will become a more and more important thing that we need to keep looking at. So it's wonderful to see some of my students out there in the internet world tonight, like Gelly. So thank you for coming along. I might just share my most close-up experience of the way that the International Labour Organization operates to drive change forward in countries like Australia, but also in countries where the circumstances are much more difficult and which might seem impossible situations for international law to work effectively in. And that's Myanmar. So over the course of a decade, I've done a lot of work in Myanmar on human rights issues, on constitutionalism and democracy. And the country was a dictatorship for half a century. and in the worst days of the dictatorship were the period probably from 2000 to 2005, 2006. But it was in that period that the International Labour Organization called Myanmar, or Burma as it was known then, to account for what were incredibly grievous acts of forced labour and slavery carried out by the military on villages, on women and children, often in the context of civil war. They would force men and women to act as human shields, as porters, to walk through minefields before the military, carrying the military's weapons in dangerous circumstances, building the military's roads. Absolute outrageous violations of the International Labour Organization's very principles. But when Burma was first granted independence at the end of the Second World War, in a flurry of commitment to the international global order, Burma's leaders signed a bunch of international conventions. They signed the Convention Against Genocide, and they signed up to the International Labour Organization's conventions that prohibit forced labour. So we had this international commitment there by a country that was a dictatorship, violating human rights all over the place. And the International Labour Organization conducted a study, did a review, set up a commission of inquiry, found that there were violations of the convention, and said to Myanmar, following a judgment by the International Court of Justice, now comply. And we might think, well, a dictatorship would just say no. But the actual fact of it is that in extreme circumstances, a judgment of the International Court of Justice could be referred to the Security Council to be actually enforced. It's never happened, but it could happen. And that leverage, that threat, was enough for Myanmar to take extraordinary action to actually reduce the prevalence of forced labour in that country, even when it was a dictatorship. They had International Labour Organization officers in the country doing work there. It was the one ray of light in a very, very dark time in that country. And people, when they look forward a couple of years to Myanmar having a referendum in 2010, and then elections and the release of political prisoners, and about a decade of democracy before it has reverted tragically to military dictatorship again, they see the ILO engagement with Myanmar as one of the cracks that let the light in for a brief period of time. So it's important that we keep front and center when the Shadow Attorney General says things like Australia's really dragging its heels on signing protocols to ILO treaties, that we have in mind exactly what that means and what that signals, what it tells the world about what Australia's views of the importance of the international liberal order are, because it's not without power. So we have...
Catherine, do you mind if I actually jump in on that?
Sure.
Because this is an issue that's come up in other contexts. A lot of that work that you've been describing is done by Australia's representatives in international spaces, by diplomats involved in the multilateral work, by diplomats in countries such as Myanmar. And if you've lived abroad, you've probably engaged with them, and you've seen firsthand, the excellent kind of work that they do. The Australia's diplomatic investment now is quite minimal. Our international footprint, the Lowy Institute are always reporting on this. Our international footprint is not equal to our where it needs to be, essentially. And given that a lot of the modern slavery issues, a huge amount is in our region, a huge amount we have a degree of moral culpability for, because it's related to what we buy or supply chains that our companies rely on. How much more, or how much more of a diplomatic effort can we be doing, or should we be doing? The ILO is not an organization that I'm familiar with, and is there scope for reviewing our diplomatic investment to support work in this field?
Do you want to make a comment on that, Mark?
I think there's absolutely scope for us to do more with multilateral organisations, and that's a general comment right across the board, not just the ILO, but with United Nations organisations as well. There's been a narrowing of Australian diplomatic activity over the 9 years of Liberal government. We've reduced our involvement in the United Nations Framework Convention on Climate Change. We've reduced our involvement in a range of UN bodies. We've reduced the contact that we have with the International Labour Organization, and in favour of, it seems, increasing closeness with the United Kingdom and the United States. But that I'm not from one moment saying we shouldn't continue to be close to the United Kingdom and the United States, but really, since the Second World War, since the great role that Australia played in the establishment of the United Nations, we've shown ourselves to be great participants in international multilateral organisations, and we need to do more of it.
Yep, I agree. So there was an excellent question in the chat about, well, what can consumers and unions do? And we have evidence on that from around the world now, that many of the positive changes that we've seen have been driven from the bottom up by consumers insisting on manufacturers, for example, declaring that the products that are being sold have been made without the use of forced labour and with veracity in the supply chain links. And that's something that has been extremely positive and heartening, is seeing consumers themselves starting to call the shots with the companies and the manufacturers themselves. I mean, we've seen it clearly in the fashion industry. I think there was that awful incident in 2016 when Rip Curl, an iconic Australian brand, was found to be using forced labour from North Korea in the manufacturing of its products. And obviously, when a light's shone on this, the practice of companies change. But I mean, the outcry from consumers was immediate and powerful. But so much of that turns on knowledge, on revealing what's going on in the supply chains. And that's where a lot of companies in the recent flurry of reporting seem to be making a paper compliance checklist that doesn't necessarily involve doing the hard work at second tier supply level end of things.
Can I add to that as well? In terms of what unions can do, there's one very obvious thing, which is keep campaigning for enforcement of basic workplace standards. Because if we're talking about forced labor or unpaid labor, often this is in industries where there's a large number of immigrant workers or temporary workers who don't have deep connections to the Australian community, are less familiar with the Australian legal system. Maybe their English isn't as good, so they're not familiar with how to access representation or support networks. And they're open, easy to exploit. And making sure that workers are not being exploited is core union business. It always has been. And it doesn't matter if these are workers born in Australia or workers currently in Australia, or workers who just make things that are bought in Australia, or just part of the international labour movement. This is core union work to make sure that people's labour isn't being exploited. So there's a very obvious range of things that unions can do on that front. You would think that the National Party would be very interested in this, because a big part of the temporary visa program is focused on farm workers. They don't seem to care. They don't seem to talk about this at all. But that is part of farm workers, retail, food services. These are all sectors where there's a lot of labour exploitation due to these kind of lack of engagement in the community, I suppose you'd say, that make people more vulnerable than they should be. And that's one thing that organisers can do.
There was a question about detention and asylum seekers, and isn't detention of asylum seekers something, forced deprivation of liberty, etc., that would fall within the modern slavery sort of framework? But the truth with that is that you don't need to try and draw a link with the modern slavery framework to find human rights violations in that particular space, because there are so many other international conventions that are applicable to that situation. And there's a lot of work has been done by special rapporteurs on identifying how Australia's in breach of international conventions in relation to our treatment of asylum seekers. Convention Against Torture and Convention on the Rights of the Child are two that spring to mind as well. In the dying minutes of the seminar, and just before it completely dies, I do want to thank you all for giving up your Tuesday night, and particularly you, Mark. It's just amazing to have you with us, and you as well, Dom. It's equally amazing to have you with us. But Mark, would you like to say a few words about anything else interesting or important that Labor might have on its agenda in the realm of your wheelhouse, while we've got you?
I'm certainly going to burn up your remaining 5 minutes, Catherine, if you give me that sort of invitation. But I've got to say, the primary, to shift topics and just to end on modern slavery and say there's a lot that could be done. We need to be not only the ratification of the ILO Convention, we need to be, as a government, publishing an annual list of countries that of regions, of industries and products where there's a high risk of modern slavery, including forced labour. We need to make sure that companies that are importing from those places would have an onus placed on them to prove that goods are not made with forced labour. We need to consider targeted sanctions on foreign companies and officials that are known to be directly profiting from, for example, Uyghur forced labour. There's a lot more that could be done, and it's one of the long list of reasons why I hope to see a Labor government elected in a few weeks' time. But in my particular policy area, the number one issue is our commitment to create a National Anti-Corruption Commission, which we took to the last election. And shockingly, to me, the government took a commitment to do a National Anti-Corruption Commission to the last election. Here we are at the next election. If you'd asked me on the very disappointing and gloomy day after the last federal election in 2019, when we woke up to find that we had not been successful, and if you'd asked me, will the government do this? Because they'd made it a very, very clear commitment. Morrison stood up with his then Attorney General, Christian Porter, on the 13th of December 2018 in Sydney, gave a very long press conference explaining why they were going to do a National Anti-Corruption Commission. They haven't done it. And it's possibly a blessing if we are elected, because it means I won't have to clear away the wreckage of their grossly inadequate model. And on a campaigning point of view, it's yet another announcement that Mr. Morrison made that he hasn't delivered on. It's yet another commitment that he made that he hasn't delivered on. And it's really clear why he hasn't. It's because the sea of rorts that surround this government, the misuse of taxpayers' money, treating it as if it was Liberal Party money, that's the reason they haven't done it. They don't want to see a National Anti-Corruption Commission examining the way in which they have governed. And I'm looking forward to creating a National Anti-Corruption Commission, which I hope will be the best practice model in Australia. We've got the advantage that every state and both territories have had an anti-corruption commission now for over a decade. Some states, New South Wales in particular, have had an anti-corruption commission for 3 decades. And we've been able to learn from mistakes that have been made, and all of them have made mistakes, from deficiencies that have been exposed in the models that have been adopted in the 6 states and the 2 territories. And I'm hoping we can learn from all of that experience. It's the one silver lining in the cloud of the Commonwealth not having an anti-corruption commission, that we're able to learn from the experience of the states and territories and get it absolutely right. The other one big commitment in my portfolio is, because I've got responsibility for constitutional reform, I am so looking forward to organising, and this is a commitment that's squarely and clearly made, repeated again by our leader Anthony Albanese in the budget reply speech last Thursday, that we will be taking a referendum to the Australian people in the next term, if we are elected, to implement Indigenous recognition and a voice to Parliament in the Constitution. It'll be the first referendum for 23 years. The last time we had a go was the Republic referendum in 1999. I used to say in my first couple of years in the Parliament that this was the first decade, that's not the decade we've just finished, but the one before, where Australia had not had a referendum or any attempt made to change the Constitution. We've now had 2 decades. Up until then, at least once a decade, and in the first decade of the Commonwealth, we had 5 attempts, but there have been multiple attempts to change the Constitution. I think it's really important that Australians return to the idea that our Constitution can be changed, should be modernised. That's why the founders of our federation put a provision in the Constitution that allowed for it to be changed, and we need to use it. I think myself that the Indigenous recognition and voice to Parliament subject is the most likely of all of the possible constitutional changes that we could talk about to succeed. Repeated polling tells us this, and I am so looking forward to getting on with that task and working with the Aboriginal people and Torres Strait Islander people of this country to put a voice to Parliament in the Constitution, to accept the extraordinarily generously expressed request made to the people of Australia in the statement from the heart. We should take up that invitation, and it's a great project for the next term. As you can see, Catherine, it's a terrible invitation to give me. What else would you like to talk about?
I won't
but
do
there
anything.
are 2 matters. There are 2 matters that people can think on, and as really good reasons. I'm not going to talk, well, we could talk about cost of living, we could talk about aged care, we could talk about childcare, but in my space, in the law reform space, those are the 2 really major commitments that we take to this election.
Well, they are things that come up every single time we go door knocking and standing on street corners. The people in the electorate of North Sydney raise those 2 issues. So it's wonderful to have you end our seminar this evening on that note, Mark. Thank you so much. And thank you to Dom, and most particularly, thank you so much to the audience for coming along on the Tuesday evening. I look forward to seeing you again, everyone. Thank you.
Thank
Yeah.
you.
Thanks very much, Catherine.